and she was the same prosecutor who said that the defense attorneys don't really need time to review the evidence in the case. There was a lot of discovery, and Molly was explaining that, 8 million pages, it's not that much, and they don't even need to read it because it's cumulative and duplicative. And what Molly did for the defense attorneys, because she's such a nice prosecutor, she organized it all for them. So you can see they just deleting stuff out. So think of it, it's all being bundled up in the original, and now they're trying to parse it out. Uh-oh, we have a bunch of bad jelly beans. You are such a little goofer, Jack. You are, as we know, you've been adjudicated illegal. Sorry, buddy boy. You are illegal. You're not a real prosecutor. Jack Smith returns, re-indicting President Trump. You can see a superseding indictment filed fresh out of the oven right in the middle of this election season in the District of Columbia, the D.C. Circuit. We know this is Judge Chutkan's courtroom, and this case has been pretty quiet for a while. We have had a lot of time to think about it because it's been pending at the Supreme Court. At the Supreme Court, we were arguing over immunity because there was an original indictment that had a lot of immune conduct as alleged by Trump. And so let's get our bearings straight. Where are we? This is Jack Smith's, who is not even a real prosecutor, as Judge Eileen Cannon told us, said you're illegitimate, you've stolen money, you were illegally appointed, there's no power for you. Congress doesn't have any statute by law that authorizes you, so get out. So that case is gone bye-bye. Jack Smith is appealing this, but we're now in Washington, D.C. on the January 6th case, not the classified documents case. We remember back on this case, we have Molly Gaston, who has been writing many motions in this matter from the beginning. We've been covering her work, and she was the same prosecutor who said that the defense attorneys don't really need time to review the evidence in the case. There was a lot of discovery, and Molly was explaining that, 8 million pages, it's not that much, and they don't even need to read it because it's cumulative and duplicative. And what Molly did for the defense attorneys, because she's such a nice prosecutor, she organized it all for them. Put little tabs on it and highlighted it and put some sticky notes in there and a little table of contents and said, here you go, defense lawyers, I've organized it for you. Of course, a defense attorney wouldn't give a crap about what a prosecutor says are the most important pieces of their case or something. Thank you for that. How about you don't touch the evidence? You just give it to us, right? We'd like to know kind of where things are and things like that, but that doesn't give you a basis for saying we don't get to review it. We need like 2 weeks or 2 months to review 8 million pages of documents? No. Your little organizational skills don't replace discoverability and discovery review, Molly. Anyway, so she's back on those cases, we can tell. And this is the government now noticing the court, Judge Chutkan, that there is going to be a superseding indictment. And that means there's a new indictment, right? We had an old one. Think of the first one, the original indictment, as first draft 1. That draft had some problems in it. So what we're going to be doing is replace it. Now, oftentimes what you see in a superseding indictment is new charges. You see something substantial that has changed, but no, not in this case. In fact, well, there are things that changed, but it's Jack Smith taking out the problems that were in the first indictment. It says today, a federal grand jury in D.C. returned a superseding indictment, a new one, second draft, charging the defendant, in this case Trump, with the same criminal offenses that were charged in the original indictment. Now, the superseding indictment, which was presented to a new grand jury that had not previously heard evidence in this case, so it's like a fresh slate, blank slate, a start over, reflects the government's efforts to respect and to implement what the Supreme Court said that we have to do in their Trump decision, this case, which went up to the Supreme Court and was decided in favor of Trump, that there is presidential immunity. Now, it's not absolute for everything that you do while you're the president, as the weirdos on the left would have you believe, although no one ever made that argument ever, except them in their minds. There's different categories, and you can have a presumption of immunity for official conduct, or at least conduct that's arguably official. If it's presidential conduct, if it's official conduct, if it is something that the president has the constitutional power to do, of course that's immune. Can't prosecute the president for doing their job, obviously, which was always obvious, except for the legal scholars like Judge Lawgic. So wrong on everything he's ever said, but he's on CNN every night. But the government does not oppose waiver of Trump's appearance, we're kind of starting this over a little bit, for arraignment on the superseding indictment, because he needs to be arraigned on the new charges and the new facts underlying the charges. As this court directed, remember, the government will confer with the defense and make a joint proposal to the extent possible regarding pretrial litigation in the status report that's due on Friday. Okay, so there it is. So Jack Smith is scrambling to get this done before he has to tell the judge how he wants to handle this case. Because the way that he's going to have to handle this case, based on this report, is going to be pretty bad for him. So let me just share with you what this looks like when you compare and contrast these two documents. So you can see over here on the left, we have the original indictment. You see this one was filed August 1st, 2023. It's a 45-pager. This is the new indictment filed August 27th, just over a year, and it's a 36-pager. As we scroll through this, first page, largely the same. Superseding indictment versus the word indictment on this. As we scroll down, we're trying to determine where the differences are between the two documents. Now you can see here that this paragraph looks like it's been deleted. So right here before count 1, you see count 1 right here. There's a paragraph right here. In the new indictment, they have now added a paragraph right there. And it says, in furtherance of these conspiracies, Trump tried but failed to enlist the vice president, who is also his running mate, and by virtue of the Constitution, the president of the Senate, who plays a ceremonial role. So it looks like that was added. And then we pick back up. Then we see the conspiracy is here. Donald Trump is, that looks like it's largely the same. The purpose of the conspiracy, largely the same. Now this changes a little bit. So the defendant enlisted co-conspirators. In this new indictment, we go all the way A through E in the new indictment, but in the other one, we go A through F. All right, so in the original, we go A through F. So you can see they just deleting stuff out. So think of it, it's all being bundled up in the original, and now they're trying to parse it out. Uh-oh, we have a bunch of bad jelly beans in the jelly bean jar. So we got to go pick some of those jelly beans out. Nobody likes black licorice jelly beans except my mom, Mama G. She loves it. So then you have to pull it out so that you don't poison the young kids, because if they have black licorice, they might die. So you have to pull it out, poisoned almost. So that's what Jack Smith is trying to do. He's trying to pull it out so that it's nice and clean. We're going to see if he can get away with it. But let's take a look here. So subsection 6 is talking about a political consultant who helped implement a plan to submit fraudulent slates of electors. Co-conspirator 6 is still there. Co-conspirator 2. Looks like that first one may have changed. Yeah, so they changed some of this language. Co-conspirator 1 is now a private attorney whom Trump put in charge of his campaign's litigation efforts and spread knowingly false claims. Co-conspirator 2 was someone else. This is another private attorney who worked with the vice president. This other person is another private attorney. So let's continue. The federal government function, that looks largely the same. Manner and means looks a lot the same. And we're just getting another revision of the paragraphs here. You can see D is the extent of this, and it looks like one of these paragraphs was also deleted. Yeah, all right. So you get the point. So as we're going through this, you can see it looks like basically what they're parsing out is stuff that they think is immune. So in other words, Trump, some of the stuff in the original indictment was absolutely immune, so they just took it out. It looks like it's references maybe to the DOJ and stuff that the president was working on with the government at the time. So in Georgia, right, the old indictment's just going through the same states, same things happening over here. We're going to go through the same stuff. So Michigan, same as the original indictment, Pennsylvania, Wisconsin, and so on. New indictments on the right, old indictments on the left. And what you'll really notice, it's the same charges. Okay, so this is kind of the big takeaway on this. Nothing has changed in terms of the charges. So at the very top here, you'll see old indictment and new indictment have the same charges. So at the top, 18 U.S. Code 371, 18 U.S. Code 371, 18 U.S. Code 1512K, 1512K. Now the one that's interesting here is 1512C2, 1512C2. And our friend Good Lawgic caught this. He says, you know, they didn't even modify this at all. Nothing has really changed in here. And 1512C2, there was a Supreme Court decision on this that was very impactful. Good Lawgic, our friend on YouTube right next door, says they are still trying to use 18 U.S. Code 1512C, which is in both indictments, even though it was specifically knocked out by SCOTUS 2 months ago in Fisher. He says Jack Smith is really bad at this. And we recall that this happened because in this Supreme Court decision, in the Supreme Court of the United States, they told us that if you're going to charge somebody, in this case, Trump, okay, this is the new indictment, the superseding indictment, the second draft of the first indictment. You see this charge, 1512C2, it is obstruction of, so Trump actually did this, and then he attempted to obstruct an official proceeding. And so if Jack Smith is going to fix his indictment, if he's going to fix his problem, people are wondering why he didn't fix this little situation here. And so if you recall from 1512C2, from the Supreme Court case, they said that if you're going to actually get Trump on this, the government must establish that the defendant in this case, it was Fisher, but as it applies to Trump, we're talking about Trump, whether Trump impaired the availability or the integrity for use in an official proceeding of records, documents, objects, or other things used in an official proceeding or even attempted to do so, right? So attempted to or did it under 15c2. So what this means is it's very specific. Records, documents, objects, or other things in the official proceeding. It cannot be just, people rioting, causing a ruckus outside the proceeding to interrupt the proceeding. In other words, it needs to be like broad. Like, it needs to be specific. It cannot be broad. Like actual documents. Did they come in there and rip up the documents like Nancy Pelosi did? Did they come and smash the gavel? Did they come and knock the podium over? Whatever. But you actually have to impair the availability or the integrity for use, right? You gotta use the thing in the official proceeding. It's very specific. You gotta wreck something, the documents, the gavel, record, something, right? It's kind of an evidentiary rule. If you're wrecking it, you're in trouble. So we can't wreck the stuff that we need for our proceedings or other things that are used in an official proceeding. This is what the Supreme Court said, okay? It's narrow. It's not broad. And as we see in this superseding indictment, it's much the same, right? What we'll see here is it says, despite having lost, Trump, who was the incumbent president, was determined to remain in power. Those claims were false. He was a candidate. He had a right, like every American, to speak publicly and so on. It's a fresh indictment, so there will be more to be revealed. Jack Smith, special counsel. Jack, you are such a little goofer, Jack. You are, as we know, you've been adjudicated illegal. Sorry, buddy boy. You are illegal. You're not a real prosecutor. A federal judge, Eileen Cannon, has adjudicated you to be improperly appointed and a thief of $24 million and counting. We're going to be here continuing to cover this, my friends. Thank you for joining us as we do. We're looking forward to Trump's response on this J6 case. And the timing on this is also very curious. Trump's indicted again. You just indicted him already. It's the same indictment, really. You're just trying to clean it up. Jack Smith is trying to avoid what the Supreme Court told him to do. He's trying to just kind of think that the defense team is going to be okay with Jack Smith's argument that he just whited out the bad stuff. He just pulled out the black licorice jelly beans. No one's buying it, Jack. You're not a real boy. Get out. You're illegal.